Is everybody ready?
Yep, so we're on YouTube and we're recording, so we're good.
Good morning. My name is Michael Moran, and I am serving today as the chair of the Zoning Board of Appeals. I would like to take a minute to remind everybody about the rules of this proceeding. This proceeding is at all times governed by the rules of procedure adopted by the board on October 17, 2011, as amended on February 20th, 2014, May 18th, 2017, and January 17th, 2019. A copy of the rules of procedure is available for review online. This is a quasi-judicial hearing. As such, the board reserves the right to deliberate in private. The Ohio rules of evidence do not apply to this hearing. However, professional rules of conduct do apply, and candor to the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. Any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being recorded. Therefore, please speak clearly and state your name and address for the record. In the event any technical difficulties with the video conferencing technologies, I may continue or postpone this hearing at my discretion. All participants providing testimony must have both camera and audio features turned on to participate. With that said, we shall proceed to the first case. The case today is case number Z-4061-2021. The applicant is Mountain Lookout Community Council, and they're represented by Sean Suter. The appellee is R2 Partnerships, L&D Real Estate Holdings, L&D Real Estate Properties, Mr. Barry Rosenberg, and he is represented by Kathy Ryan. Is that correct?
Yes.
We shall proceed. Any notes from Mr. Haynes or Mr. Tidd prior to us proceeding? Oh, okay. We are going to start with the applicant. Just as a course of business, we'll let the applicant proceed with their case. Ms. Ryan, you will have a chance to show your hearings. Mr. Suter, as the applicant, you have a right to rebut, and then we'll do closing declarations. Mr. Suter, we'll go ahead and start with you.
Thank you. Chairman, this is Kathy Ryan. I submitted letters on July 7th and 8th asserting that the scope of the appeal is under dispute. And if I may, I would request that the ZBA hold a hearing preliminarily on the scope as disputed in my letters and the attachment from Sean Suter, so that we understand moving forward what the scope will be for the hearing before the board as far as the substantive matters go.
So we are in receipt of the letters of July 7th and July 8th. Our understanding of this meeting is with regards to the demolition permit that was approved by the zoning hearing examiners, and that is the scope of this case. Mr. Haynes or Mr. Tidd, do you have any comments regarding procedure here?
Mr. Chair, I think that Ms. Ryan has submitted her written arguments for the record, and the rules will allow her to present those arguments during the time allotted to her. So I think that my recommendation to the chair would be that we proceed in accordance with the normal rules, and Ms. Ryan can raise any objections that she has during her response to Mr. Suter's presentation.
I would agree. Is there any other comments by the board? Okay.
Chairman, if I may, just to be clear, I believe that you stated that the appellants are here regarding solely the demolition permit. I guess I'd like to at least get clarification of the board's position prior to proceeding, if this is in fact just about the demolition permit from the board's perspective.
It is our understanding that in reading the appeal, that's what this appeal is about, is the item on the zoning hearings committee findings, and the appeal is about the demolition of the property.
Thank you.
Let's go ahead with Mr. Suter's argument.
Thank you, Mr. Chairman, members of the ZBA, members of staff, everyone who's here today for your time. I don't think the issue is in dispute that's before you. It's a very narrow issue, as Mr. Moran said, on appeal, and it's related to the use of the use variance by the zoning hearing examiner to grant approval of demolition in the urban design overlay district in Mount Lookout. I'm Sean Suter. I represent the Mount Lookout Community Council on this matter. There are, I believe, I can't tell who's on here, but several members of the Mount Lookout Community Council who are joining us today. But this is not about witnesses or facts. This is a case solely about the application of the law. And we believe the law was applied by the zoning hearing examiner illegally, and that's what we're challenging here today on appeal. We're asking the Zoning Board of Appeals to overrule or to vacate the decision by the zoning hearing examiner relative to the use variance that was granted that effectually allows the demolition of the homes, the single-family residences, residential buildings are not being used that way, but the single-family houses on Delta Avenue there. So the question before you is, was the zoning hearing examiner's application of the use variance to grant relief from the no demolition rule in the urban design overlay district, was that illegal? That's what we're arguing, that it is illegal, and we're asking it to be vacated. If it isn't, which we believe it isn't under the law, then the ZHE's decision relative to demolition, like I said, is invalid and should be vacated. Now, this is something that the ZBA recommended. The ZBA, your board recommended to the zoning hearing examiner on remand that he apply a use variance standard to the issue of demolition. I understand why the Zoning Board of Appeals did that. I can understand it, but I don't agree with it. And so bear with me, as I don't believe you were privy to some of our legal arguments at the time that you were given that direction, or the time that you gave that direction to the zoning hearing examiner. So I ask you to please, oblige me in allowing me to make those arguments now that weren't available to you, I don't believe, at the time. First question here for you to understand is, what is a use variance? And I think we have to take a look at that to understand why our argument is that the application of it was illegal. The Cincinnati Zoning Code, like most zoning codes, will contain use classifications, permitted uses, conditional uses, special exceptions. They either permit uses or they don't allow uses. They either conditionally permit or permit them by special exception. Where use is not allowed in the use table, a property owner can ask the zoning hearing examiner for a use variance to allow. That's what a use variance is. For example, if I have let's say I have a single family residential, let's say I have a church that's in the manufacturing district. It's no longer being used as a church, but I want to turn it into my house. Well, single family residential isn't allowed in the MG manufacturing district. So I can come to the city and say, you know what, I can't use this church for anything. The only thing I can use this church for that's economically viable is a single family residence. That's what I want to use it for. Please, zoning hearing examiner, weigh the factors and grant me the right to do so, because if I can't use it for that, then I can't use it for anything. Essentially, it's taking my property. That's the application of a use variance in the Cincinnati Zoning Code. That's how it's applied in other communities, just about everywhere. I'm familiar with its use. It doesn't show up everywhere around the state and around the country, but it certainly is used that way most typically. Allowing a use that's not allowed in the use table, and that's how it's used. And that's how it was used in the Shoemaker case of the Ohio Supreme Court. How it's not used is as a catch-all provision that allows the zoning hearing examiner just to vary any provision in the zoning code that it is asked to vary. Whether that's trying to avoid a taking or not, it doesn't matter. There are only specific instances when the use variance is allowed. And the purpose of the use variance, like I said, is to vary uses that aren't permitted for in a specific zone. It's not a catch-all relief valve. And I think that's the way it was applied here, because really it was viewed, I believe, by the Zoning Board of Appeals, whoever was advising the Zoning Board of Appeals at the time, essentially as, hey, we have no process here to get to the issue of demolition. And I would argue that there is no process to vary or to give relief from the issue of demolition in an urban design overlay district. In an urban design overlay district, demolition isn't allowed, and that's to preserve our urban design overlay districts, our business districts like Mount Lookout. It's not allowed unless the building is falling down, essentially, unless it's been condemned by the Department of Buildings and Inspections. And the Director of Buildings and Inspections comes in and says, it's got to come down. And they issue a demolition order. That's when a building in the UDOD comes down. Now, right, wrong, or indifferent, that may be a little harsh. But that's up to the City Council. I know that the City of Cincinnati is looking at legislation now. I don't know where it stands, but, at fixing this to allow maybe demolition in the urban design overlay district in circumstances other than when there is a demolition order. And that's fine. That's City Council's prerogative to do that. And I think that gives evidence that there's a problem with the code here. But the code is written it is what it is. And it says, unless there's a demolition order, there's no demolition. Now, there's no relief valve for that in the code. The ZHE cannot grant a use variance in this context. There's no mechanism that allows them to do so. The zoning administrator correctly determined that the Director of Buildings and Inspections did not order the demolition. There's no fact in dispute there. There's no issue in dispute. It is what it is. Look, the director did not order demo. These buildings were not condemned. They're not ordered to come down. And that's the only way the building can be demolished in an urban design overlay district. Like I said, right, wrong, or different, that's the law. There are no facts in dispute here. No demo is allowed here. And the zoning hearing examiner cannot unilaterally allow what is prohibited by the code. And that is what City Council can do. And City Council can do that through a notwithstanding ordinance, which is the appropriate venue for this. If I had been advising this applicant, which I wasn't, but if I had been, I would have said, go get a notwithstanding ordinance. And that's the process by which you would vary something in extraordinary circumstances where you can't otherwise get relief. I would not have directed them to a use variance, because this is not the appropriate use of a use variance under the law, under Ohio law or the city's code. So that's really the long and short of our argument. The ZHE has erred in applying the use variance. We believe that was done unlawfully, and that its decision relative to the use variance must be vacated by this board. And that's what I have. I appreciate the opportunity to provide a rebuttal argument after we hear from Ms. Ryan. Thank you, Mr. Chairman. Thank you, members of the board.
Thank you, Mr. Suter. We'll give Ms. Ryan a chance to present her case.
Thank you, Chairman and members of the board. My name is Kathy Ryan, representing the appellees in this case. As you know, and as Mr. Suter had mentioned, that we are here having requested the use variance as a result of the direction of the board. As found in the record on page 101, the board instructed us on December 5th to pursue the use variance for the demolition. That was the source of, or that was the basis of this request. And the reason for it was that, as Sean had mentioned, this 143709 ID1 has this highly prohibitive language where any building in the urban design district cannot be demolished for any reason whatsoever unless the Director of Buildings and Inspections has ordered it to come down. And just very briefly, as we had previously noted to this board, that deprives the applicant, the property owner, of any sort of administrative procedure where they would get an opportunity to say why they should be the exception to the rule. And what I said at the time was, as an example, by way of example, the historic board dubs certain buildings historic and prohibited from demolition, but nonetheless provides a procedure in the code that gives a property owner an opportunity to at least be heard as to why they think they should be the exception to the rule. That is something that is a preservation of due process rights and something that should always be present in any situation where the property rights of the owner are suppressed by way of this demolition prohibition. And so when we argued that, our other point was that this is a non-conforming use, non-conforming to the district, urban design, CNP district, hillside district, and the purpose of the demolition is to replace it with something that is more in keeping. So as part of filing that request, we were beholden to the use variance standards, which is a high standard in the code. It's the highest burden of proof available. Everything else in the code, in the zoning code rather, is something for which a preponderance of the evidence, 50-50, is required to be proven by someone requesting relief from the code. In this particular case, for use variances, you need to prove by clear and convincing evidence that you have met the standards of the use variance. And as part of that, we were requesting essentially that the use to which we want to bring the property back to is vacant land. There is nothing in the code that says what a use in the phrase use variance is defined as. That's an ambiguity in the code that should be interpreted in favor of the property owner. I'm sure you've heard many times people refer to a vacant use of land. And so that is the circumstances that under which we are seeking that use variance here. As Sean had mentioned, he thinks the notwithstanding ordinance would be the proper mechanism by which we would seek that relief. There are a couple points with respect to that. First, even if that were appropriate, that does not mean that it is exclusively the only remedy available. Second, as Mr. Suter had stated in his letter, he refers to that as relief from existing or from extraordinary circumstances under the law. In reality, the Municipal Code 111-5 states specifically this is, quote, relief from existing legislative and administrative procedures. We were not seeking relief from this administrative procedure. We embraced the procedure under a request that had 5 very specific standards that we were required to meet by clear and convincing evidence, and we proceeded down that route. I agree if there's a situation where the procedures present don't give any opportunity for that individual to get what they're trying to get, then perhaps the notwithstanding ordinance is the way, because it allows them to step out of the existing procedures as they exist to request something. And as part of that, another thing that's significant is that the request remedy in this case is not about the fact that, well, there's a notwithstanding ordinance. The notwithstanding ordinance is something that is adopted as an ordinance as a piece of legislation. We are always, as property owners, entitled to an administrative procedure under which we can seek relief. If we were to seek the notwithstanding ordinance, the relief there is to get a referendum with proper petition signatures within the 30-day period, get it put on the ballot and on referendum. Our point is that as an administrative procedure, and considering the fact that the due process rights are suppressed where we are being prohibited from demolishing something, the key here is that the ZBA properly recognized that there is an administrative procedure that we could seek that would allow us to get the demolition approved if we met the standards. And at the end of the day, the most important issue about this is that Ohio law recognizes under the harmless error doctrine that if this were to be a procedural error, that for some reason the notwithstanding ordinance is appropriate and use variance is not. The law states that harmless error is one which does not affect the substantial right of the parties. Mount Lookout Community Council is here before you today saying, this procedure is wrong because the procedure is wrong. They stop short of saying, and here's why doing that deprives us as the appellant of any sort of right or unduly prejudices us in any way. In fact, if anything, by us as appellee pursuing the use variance, that was to their favor. Unlike the notwithstanding ordinance, where there is no procedure that we need to stick to, they got full and fair notice in the use variance procedure. They had a chance to rebut our high standard of clear and convincing evidence. They were able to do that for the full procedure. There were no procedural shortfalls in that respect. And the same goes for them as goes for us. If they didn't like the outcome, I would argue that the administrative procedure offers a far less lofty remedy by way of the 2506 appeal that which would first come before this board, rather than having to tackle challenging any sort of legislation for which a referendum is required. I'll go on to state that was Knorr versus Parking Company of America, which we included in our letter. Again, mere proof of a procedural violation by itself is insufficient to warrant judicial relief, and Ohio courts will ignore harmless errors which do not affect the substantial rights of the parties. And Aztec International Foods, it's also quoted in the letter. In that particular one, they note that in litigation arising from parties' business disputes, although the trial court employed the clear and convincing evidence standard rather than proper preponderance of the evidence standard, because he was only seeking compensatory and punitive damages, any error was harmless. The trial courts had still found that fraud was proved under the higher burden of proof. Here, there isn't a single circumstance under which any alternative method would have made it more difficult for us and easier for the appellants. We have proceeded with the most burdensome method that anybody, either us or anyone within the Zoning Board of Appeals could conceive of, where we would be seeking that demolition. And so therefore, with no substantial rights affected, nothing prejudicing the Mount Lookout Community Council, we would argue that they've had as much of an opportunity as anyone could have within any sort of procedure or opportunity within the entire Cincinnati Municipal Code to ward off the demolition, and they have not been able to do that. And with that, I would submit that this board ruled that the use variance procedure pursued was the proper path. Thank you.
Thank you, Ms. Ryan. The applicant does have a right to rebut. Mr. Suter.
Thank you, Mr. Chairman. A few things here that I think need clarification. First, there is a process. So due process hasn't been deprived here. There is not an administrative process in the Cincinnati Zoning Code that allows for relief from the demolition rule in the Urban Design Overlay District. We can debate whether that's good or bad. I know the city's trying to fix that currently, but that's the case. That's the reality of the zoning code. And therefore, you have to look to the legislative process, the legislative variance, and that is the relief valve. That's your due process. You go to city council and you say, I have no relief in the zoning code. The zoning hearing examiner cannot provide any relief in this case. The use variance is not appropriate. City council, please, I'm begging you, I've got extraordinary circumstances here, and there is a process around that. It's not a free-for-all. Go to section 111.5 of the municipal code. There's a whole process. People within 400 feet of the subject property get notice. There's an entire process around the notwithstanding ordinance in 111-5. There are standards by which the city council has to balance public interest, private harms, private interest, public harms. So There absolutely is a process. That's the correct process. Whether they, avail themselves of that is their business, but they cannot avail themselves of a use variance. Again, that's the remedy here. So there's no due process violation. It's just a misapplication of the zoning code here and an unwillingness or inability or whatever to go seek the notwithstanding ordinance. We prefer it because it is a more public process for us as the community council, and it allows us to participate in the legislative process. But evidently that's not desired by the appellate parties. The administrative process allows us to challenge a decision on its illegality. Anyone with standing, we clearly have standing. The Mount Lookout Community Council has standing under the zoning code, and we can challenge any administrative decision where we have standing on the basis that it's illegal. And so that's exactly what we're doing here. There's nothing in the code or anywhere about any kind of harm that we have to have. We are assumed to have particularized harm because we represent the neighborhood in which this proposal is being made. It's a little disingenuous to talk about wanting this to be vacant land. We all know that there's no intention for this to be vacant land, maybe for a moment in time after they demolish these buildings before they build the new ones. But to say that they are seeking a use variance from the permitted use on this property to vacant land just isn't so, unless they're willing to submit here today that that's what they're planning on using the property for, is vacant land indefinitely. I don't think that's the case. So we know that they're seeking a use variance to allow for the demolition of these buildings so they can build their development. Let's all be straight up about that. And I don't see that as an appropriate means of achieving demolition under the zoning code. And thank you very much for your time and listening to our arguments today. Appreciate it.
Before we go to closing arguments, do any of the board members have any questions of either Ms. Suter or Ms. Ryan? Mr. Suter or Ms. Ryan?
I have one quick question, Mr. Chair. Mr. Suter, what of the appellee's argument, the harmless error argument, how has the community council been harmed or had their rights impinged on?
Well, thank you, Mr. Benny. Like I said, the community council is assumed to have standing here. It does have standing, and therefore they're assumed to have a particularized injury as the community in which this property is being proposed, its development is being proposed.
Ms. Powell, did you have a question?
I do. Yeah, so Mr. Suter, the community council was a party withstanding the last time this particular development was before the zoning board of appeals, and our decision remanded it for, as we know, because to have the zoning hearing examiner decide the issue of demolition. What would you say to the argument that your client should have appealed our decision back then to Common Pleas Court under a 2506 appeal? Like, why did it let it go back in here and then is arguing this when it could have just appealed our decision back in October of 2020 or whenever that was issued?
Well, I think, thank you, Ms. Powell. I think we had to see how it played out, and on remand, I don't think we would have had a final order to appeal at that point. I'm not sure there was an interlocutory appeal that's allowed in this process. So I think we had to wait for the process to play out before and get a final order.
Anything else from board members? Seeing no more questions, we're going to move to closing statements. My request to Mr. Suter and Ms. Ryan is that we keep these brief. As the appellee, Ms. Ryan gets the first opportunity. The floor is yours, Ms. Ryan.
Mr. Chair, may I ask one more question of Mr. Suter?
Sure.
Mr. Suter, what at this point, given all of the revisions that have been made to the development plans, what at this point is the community council's objection, aside from the process that was taken, the use of the use variance? Setting that aside, the actual development itself, what's the community council's objection at this point?
Thank you, Mr. Benny. I would have to refer you to Brian Spittler, who's on the phone, on the line, as well as there may be others. I'm not sure who's on here. I can't see. Please pipe up if you want to address Mr. Benny's question as to what the issues are. If we're setting aside the procedural issue only and talking about the merits, which we didn't appeal, but if you're curious about that, Mr. Spittler, do you want to take that?
Yeah, I'll try my best, because this has been a very, what I would use for lack of better terms, muddy process. There's multiple things that come to mind related to that question. Is that, Ms. Ryan makes these arguments that, we've had our processes and whatnot. And then the question from Ms. Powell came up about, why didn't we do something different? Well, we did in fact say this shouldn't be going back to the zoning hearing examiner for a whole new set of facts and whatnot. And so we just had to navigate the way we knew best, which we're not the experts, right? Talk about the fairness of process. We really don't know this process such as the other side does.
Mr. Spittler, I'm sorry to interrupt, but can we set aside the process for just one moment?
Sure.
Let's not focus on the process.
Sure.
I'm interested in hearing about the actual bricks and sticks of this proposed development.
Okay, so issues that aren't related to this hearing is what you're saying.
I think Brian, Laura Whitman's on as well.
But I can answer the question. I just want to make sure I'm clear. You're asking about issues that aren't related to this hearing process. Is that correct?
I'm asking about the development itself, the proposed apartment building, the development.
Okay.
What does the community council object to?
Okay, in general, we made multiple arguments related to the urban design overlay of the building. I think Laura can chime in on this if I'm incorrect, but our statistics were something like the building's 175% larger than any building in the neighborhood, and we quoted some of the code or some of the city plans that have been done related to our community, talking about what makes our city desirable, and as a whole, using these community advisory groups that we formed, which is representative of people throughout the community. We had architects, we had real estate agents, etc., a group of about 12 folks. The feedback that we got from that and other surveys throughout the community was that this mass, the size, the scale was just too large to fit into our square. Laura, did I summarize that relatively fair?
You're muted, Ms. Whitman.
Sorry, I had to find the unmute button. Yes, one of the biggest objections on it is the scale, mass, and bulk of this building. It's significantly bigger than all those others that are in the urban overlay district. And as we're talking, I'm trying to get those numbers that Brian was talking about, but if you compare it to all the average buildings in the districts, the width of the building is 214% bigger than the buildings that are there. And the depth of it is roughly 31%, and it's 102% taller than buildings that we have in the square. So that was our primary argument, is that it's too big for what we had wanted for the square and what our urban design plan had. The plan that they presented in this application is slightly modified from what they presented when we talked to you a couple months ago. But the overall height of the building was only reduced by between 7 to 8 feet. And the width of the building, as far as we know, pretty much remained unchanged.
Does that answer your question, Mr. Benny?
It does. So if Sean, stop me if I'm putting words in everyone's mouth. I mean, is the complaint that it doesn't fit within Mount Lookout's plan? Because I don't think any zoning relief was required for any of those specific issues, whether it was density or anything like that. The complaint is it doesn't fit in the plan because it's too big. Is that correct?
Yes, I would say that it's not in the same vein as to what we had said for the character of our community. It would change our community because of its size and massing.
And we've already been made aware of other pending applications from the developer.
To that point, with Ryan, one of our major impacts or points on this is that this is one of the first developments to come in the square for a while. We do know that there's a lot of interest for some redevelopment in the square, and what is permitted in this project has the opportunity to set the precedent of what will be allowed in the future. And if this building is allowed to be built at the size and the mass that it is currently proposed at, that means that new development can also match that, which would outscale our current square and completely change the character of it.
I think that's done. Okay, I guess we'll go to closing statements. Ms. Ryan, if you want to start.
Thank you. I believe what you've heard from Mr. Suter is that they believe that their rights have been violated and that as a board, they have standing regarding just anything like this as a possible injury. Again, he stopped short of saying why that would be the case. I would note that if you review the record is comprised almost exclusively as protests as to the new construction aspect of this request and the design of the new building. There is nothing, or I would rather say, if there is anything, there's very little protests about the demolition itself by the appellants. The plan, and I don't want to go into this because it's not being appealed, but there was a significant change in the plan that got us here. And if Mount Lookout Community Council believed that that is the thing that is the problem, I believe that their approach in filing to disrupt the demolition is simply a kind of a strategic thing. And it doesn't speak to the substance of their real motivations here, which is that they want to prevent the urban design district new construction. As you just heard their answer, they have significant issues with that, which they chose not to appeal. Had they done so, those are 7 requests with a 600-page record, and we would have probably heard a lot substantively today about that. We heard nothing to that effect. And as such, that aspect is settled. So I would ask the board to uphold the zoning hearing examiner's decision regarding the use variance and the employment of the use variance procedure.
Thank you, Ms. Ryan. Mr. Suter, you have final.
Thank you, Mr. Chairman, members of the board. The threshold matter here is whether they can build on the site. And so appellees cannot build on the site if there are buildings in the way unless they want to build around them. And so to spare everyone going through the process that Ms. Ryan mentioned with 600 pages and another huge trial, the threshold issue is what's at issue here today. And it's a matter of law. It's simply a matter of law. And we have objected to the use of the use variance. We objected in the last hearing to it. We made a motion to dismiss the case, the use variance, at least portion of the case, because we didn't believe it was legal at the time. That was denied, and we believe that that was in error, and that's exactly what we're here to challenge today. So based on the letter of the law and how it was applied, again, we believe there's due process through a notwithstanding ordinance process. They could certainly try that, but it is not appropriate to use a use variance in this manner. We ask that the use variance that was granted be vacated. Thank you, Mr. Chairman, members of the board.
Thank you for your time. That shall conclude the hearings of case Z40161-2021. Do I hear any motions for this board to go into deliberation?
So moved. Second.
So I have a motion to go into deliberation and a second. We'll do a roll call vote. Ms. Vicario,
Aye.
Mr. Benny,
Yes.
Ms. Powell,
Yes.
Ms. McKinney.
Yes.
Okay,